There's a gray area right now for marijuana users. While the substance is legal for adult use here in Massachusetts, they could run into problems when it comes to getting a job or keeping the one that they have. To explore some of the ins and outs of this issue, I spoke with two attorneys, Mike Cutler of Evans Cutler and Marylou Fabbo, a partner at Skoler, Abbott, and Presser, as well as Judy Herrell, the owner of Herrell's Ice Cream in Northampton.
We've let 3 go for coming in high on the job. Most recently, we had a gentleman come in stoned, and I spoke to him once about it. He said he wouldn't do it again. I sent him home that day, came in again, gave him a written warning, sent him home again. The 3rd time, he came in straight, went on break, came back stoned, and I had to let him go.
And so did you distinguish first between whether or not this was adult use marijuana and medicinal? Because I understand that the law has special accommodations for someone who might be using marijuana medicinally.
Right, this was not medicinal use.
And what's your concern then as a small employer, a small business owner rather, for someone who could be high on the job?
Well, they're not able to, well, I can't say all of them, but some of them are unable really to follow with the public and follow along and do their jobs well. For example, one of them put a large milkshake into a small cup, or forgets, how many times did they forget what, flavor of ice cream they were supposed to get. There's memory issues. And while usually they're very nice about it, they laugh a lot, which has its advantages, but it also has its disadvantages. There's a slowness that starts to occur sometimes too. So it's a problem. It
sounds like gets in the way of productivity is what you've observed, and even sometimes dollars and cents if they're wasting product.
And they're, counting change.
Yeah.
They're not very good at counting change, generally speaking, so when they're stoned, it's a little bit worse. I think a lot of it might have to do with the fact that we have a very young population as our employees, and they're great kids. They're great kids. They're not even kids. They're great young adults. But when they're stoned, it's a lot harder for them to interact with the public.
And so right now we're in a bit of a legal gray area, which is why we invited attorneys in today to help us understand what the current laws are. Let's talk first about employers' rights. Given that adult use marijuana is now legal in Massachusetts, how can an employer fire someone for being high on the job?
There is no inhibition, even with the legalization of marijuana, from an employer guaranteeing that he's got a competent employee who's not creating a risk of harm to himself, fellow employees, or the public. What I have a concern about under the new regime are people who are being randomly drug tested without any suspicion of their being impaired, employers finding metabolites of marijuana in their system, and then that employee being subject to either discharge or not being hired simply because of the presence of metabolites. We've got a number of court cases here in Massachusetts that say the presence of marijuana metabolites is not evidence of present impairment.
What exactly is a metabolite? Help people understand.
When people get drug tested, they're either taking urine samples, blood samples, or hair samples. By and large, there may be some other testing regimes, but that'll cover more than any other ones put together. And what those tests reveal can be the presence of what is so-called metabolites, evidence that marijuana has been within your system. But those metabolites do not evidence active impairment. The difference between alcohol testing, blood levels or urine levels, and marijuana testing is alcohol metabolites get out of your system very quickly, within a matter of an hour or two, so that if you've got a certain level,
marijuana could be days to weeks, depending,
weeks,
correct?
Up to a month that the metabolites would be there. So while the alcohol metabolites are in your system, and if you're up to 0.08% of the blood alcohol level or over, there's a presumption of impairment. Well, if you find marijuana metabolites in your system, it only means that sometime within the last month or 3 weeks you've consumed, and the level of impairment only exists for less than 2 hours after you consume. So what I have a concern with about the new law are people being tested without any suspicion that they are impaired, the finding of metabolites that doesn't mean that they were impaired, and them having a job problem behind that. I see nothing wrong with drug testing if there's been an accident or if someone's conduct is poor or their speech is impaired, some contemporaneous evidence of impairment. I see no problem with drug testing in that situation.
But Attorney Fabbo, employees in the area are allowed to drug test before someone is hired. Is that correct?
Correct. So an employer may drug test someone once they've made a job offer, and the job offer would be conditional upon passing the drug test. And in Massachusetts right now, it's entirely legal for employers to screen out applicants or discipline an employee simply because they've used recreational marijuana.
But do you see that as something that's in conflict, given that this is a substance that's now legal here, and at the same time, you might lose a job or be prohibited from getting a job if you're using?
I mean, I've got nothing wrong with, I see nothing wrong with what Judy at Herrell has described as impaired people in the workplace. She's had plenty of evidence that the people are impaired and can take a job action. What I find troubling is the statute, the new marijuana law, 94G Section 7, says that adults shall not be penalized or disqualified under the laws of the Commonwealth in any manner or denied any right or privilege for possessing or using an ounce or less of marijuana. And if it's not protecting anyone, if it's not guaranteeing any job performance, then I don't see the basis for this intrusion within your right to privacy.
For your part, it sounds like you had discussions with these former employees multiple times about this behavior. Have you developed any sort of written policy that you're now handing to new employees?
We kind of always had it. We just changed the nomenclature a little bit. We had a policy that said you can't come in high, you can't come in drunk. Now we've changed it to, we know that both alcohol and marijuana are illegal in the state for recreational use. That being said, you still cannot come to work under the influence.
In your opinions, is there something the law could be doing? There's currently not a legal limit for intoxication level for marijuana. There's a state advisory panel looking at that. Is that something that you think could help this, or is there something else? I'll start with you, Attorney Cutler.
There are impairment tests that will demonstrate a level of impairment without regard to what you're impaired with. And I think that is the future of drug testing, that whether you're impaired with a cold medication, a lack of sleep, alcohol, or cannabis, that if you're impaired at a certain level based on hand-eye coordination testing, impairment level testing, without regard to what the substance is, that I think is the future that will protect not just employers, but drivers and law enforcement.
How about for you, Attorney Fabbo?
I agree. That test sounds very like it'd be something that we would really like our clients to take advantage of. We focus on having our clients train supervisors in management and detecting impairment. We think that's a great idea, particularly when employers are hesitant to test now because of the fact that many people will test positive, maybe limiting their workforce.